Officially welcome everybody and good afternoon to our presentation today. My name is Stas Bodrov. I'm a partner at SBA Lawyers. We are a law firm with offices in three cities in Toronto, London, and Kitchener-Waterloo. We provide litigation services to a broad scope of matters ranging from uh, motor vehicle, uh, tort matters, non-vehicle property matters, human rights matters, various defense, civil litigation defense work, and we provide services in all of the southwestern Ontario and are pleased to provide you with our services. Uh, Today's seminar is being recorded, so a copy of this will be available after today. At the bottom of your screen, there is a Q&A button, so if you have any questions, please do feel free to raise those in that portion. Uh, all of our slides, any case law that we reference, any forms that we talk about will be available after the seminar. Just feel free to reach out to myself or Ryland uh, to get those. And speaking of which, our second presenter today is Ryland.
Hi, thanks, Taz. Yes, I'd just like to briefly introduce myself. My name is Riley McDonald. I'm a partner at SBA Lawyers. My practice involves mainly defense of human rights cases, primarily the defense of condo corporations and property managers, as well as I do defense for insurers and AV claims, fraud investigations, and bodily injury claims.
Thank you, Ryland. So without further ado, we'll get going with today's presentation. We've called it Fast Tracking Justice, Human Rights, and Summary Hearings Explained. We're going to start off today with just a quick discussion about the background of human rights law in Ontario. We'll move on then to talking about discrimination, how it's defined under the Human Rights Code, accommodation that is required if there is any discrimination or any issues under the code itself. Going to briefly talk about the Human Rights Tribunal of Ontario. Then Ryland is going to give us some stats, some background. He's going to get into the summary hearing process itself uh, and the grounds for bringing a summary hearing and a couple of the main issues that are typically raised, specifically jurisdiction within of the Human Rights Tribunal and a very fun area, unpleasant interactions and how those cases are dealt with by the Human Rights Tribunal. But first, let's start off with human rights in Ontario. The human rights in Ontario are prescribed by the Ontario Human Rights Code, which I'm going to refer to as the code. It sets out and it applies to 5 social areas where those human rights are legally protected in Ontario from discrimination. Those 5 areas are accommodation, specifically what that means is housing matters, in contracts, in employment, goods, services, and facilities, and membership in unions, trade, or professional associations. So the code applies to these 5 social areas. If a matter arises outside of these 5 social areas, the Ontario Human Rights Code does not apply. Now, when we talk about the code and whether or not it applies, we need to first establish, the individual needs to first establish that there is discrimination. Specifically, the code requires that a claimant prove prima facie discrimination, which is a Latin term which basically means just on its face, a claim has to have the flavor of discrimination. In order to establish this, an individual needs to prove or show 3 elements. The first is that they have that a characteristic that is protected by the code, which I'll set those out in a few moments. That the individual experienced an adverse treatment or impact within one of the social areas, the 5 that I just mentioned a few moments ago, and that the protected characteristic was a factor in that individual's adverse treatment or impact. So that is once those 3 elements are established, the individual is able to show that they have been discriminated against. Now, there are 2 different ways that discrimination can be established, and that's by way of direct discrimination or indirect discrimination. Direct discrimination is when an action itself is discriminatory and when the person acts on his or her own behalf. So, an example of direct discrimination would be a building manager who refuses to rent an apartment because they prefer to rent it to someone of their own ethnic background. So, the ethnic background is the discriminatory factor. Indirect discrimination is when the discrimination is carried out through another person. So, if we use the same example, it's where a building manager would tell, let's say, their superintendent to rent to people of a certain ethnic group or not to rent to a specific ethnic group because, for example, they're known to have certain behavior or their food smells or something along those lines. That manager who directed their superintendent can be named in a human rights claim because they used the superintendent to indirectly discriminate against people because of their ethnic origin. The basis for that discrimination, as I mentioned, are the characteristics. So, under the code, there are 17 enumerated protected grounds, and those are citizenship, race, place of origin, ethnic origin, color, ancestry, disability, age, creed, sex/pregnancy, family status, marital status, sexual orientation, gender identity, gender expression, receipt of public assistance, that's specific to housing, and record of offenses, and that's specific to employment. So, if an individual is able to establish that they satisfy one of those characteristics, and that it was based on one of those characteristics that they were adversely treated against, they are able to establish prima facie discrimination. So, what happens when an individual is able to establish the prima facie discrimination? The code requires that the organization provide accommodation to that individual. Now, as I mentioned, the claimant first has to establish that they have one of the enumerated characteristics. They need to establish that they've been treated adversely and that the characteristic played a factor in that adverse treatment. Once they're able to establish this, the obligation shifts to the organization to accommodate that individual. Now, accommodation has two factors to it. One is a procedural duty of accommodation, and one is a substantive duty. The procedural duty is, well, procedural in nature. It requires that certain considerations be made and that certain steps be taken. Now, this is, again, specific to different situations and is very fact dependent. But a procedural duty as a whole in general involves the consideration and assessment and steps taken that are needed to respond to an accommodation need. So, for example, a failure to give any thought or consideration to an accommodation request uh, would be seen as a breach of that procedural duty. So, what would fall under the procedural duty is items like listening and acknowledging an individual's needs, inquiring about the individual's needs, investigating those needs, communicating with the individual, and ultimately providing an answer and explaining why an accommodation is or is not granted. In many cases that we see, well, not many, in some cases that we see, the some organizations have a very set procedure on how to deal with accommodation requests. They keep track of them in certain folders. They jot down exactly what steps are taken, exactly when those interactions occur. They keep email exchanges between the individual and the corporation, and are able to point to exactly how they procedurally treated the accommodation request. In some cases, we see that on occasion, organizations don't provide an explicit answer to the request for accommodation, which does create some procedural issues, and occasionally don't provide reasoning as to why or why not an accommodation is not being granted. Uh, Although there might be inferred reasons, the Human Rights Tribunal, if the matter does escalate to that point, there would need to be some kind of quote unquote paper trail to explain the reasoning of the corporation. So that's the procedural duty. Now, the substantive duty to accommodate is rather straightforward. It's whether the appropriateness or reasonableness of the chosen accommodation and the reasons that are provided for not providing an accommodation, up to the point of undue hardship. So the code requires that where an individual has satisfied prima facie discrimination, they the responding party must provide an accommodation, a substantive accommodation up to the point of undue hardship. Now, this is difficult to qualify in a broad sense because every case is fact dependent, and it really depends on the accommodation that is being requested and really by the individual, and really the resources or the abilities of the organization that's being asked to accommodate an individual's need. In some situations, a request may be that the individual be provided a closer parking spot to the entrance of their building to accommodate a medical issue. It could be allowing an employee to work from home every so often due to medical reasons. It could be having cleaning staff use less toxic cleaning solutions in a hallway where a pregnant individual resides. These are all examples of accommodation which may be reasonable in a circumstance where an individual has a prima facie case of discrimination. Uh, Other issue in other circumstances, however, for example, a person asking for a ramp to be put into their building, that may be more difficult to accommodate. It might take a protracted time to have an architect come in and design the ramp, do an analysis of the area of where a ramp can or should be put in. It could first of all, it would may require significant funds that the corporation may not have at that time. It may require the condo unit owners to pool money together to pay for that ramp. So that's a substantive response there may not come for a year, 2 years, or 3 years. But in every one of these situations, the tribunal will look at the specific facts of this case to see whether or not that would be defined as an undue hardship onto the organization, or if that's something that the organization could have done faster or could have accommodated the individual. I note that satisfying one of these two duties, the procedural or the substantive requirement, does not necessarily mean that the other is satisfied. So there are cases where an organization has accommodated an individual, but they failed to satisfy their procedural duty because they had no process in place to uh, accept accommodation requests, properly analyze them, and correspond with the individual. A case that comes to mind for me is an organization that did not communicate with an individual at all after an accommodation request was made. Despite substantively accommodating the individual, there was no communication with that individual regarding their accommodation request. So, if that matter were to be brought before the Human Rights Tribunal, the tribunal might find that although substantively the corporation accommodated, they may not have satisfied the procedural duty, which may expose it to some damages. Now, this brings me to the Human Rights Tribunal of Ontario. If an individual thinks that they have been discriminated against and that the corporation did not accommodate that individual, they can bring an application before the Human Rights Tribunal of Ontario. I do note here that the tribunal has concurrent jurisdiction to resolve human rights complaints, which means that they don't aren't the only entity that that can apply the human rights code. The courts as well as other tribunals do have the power to employ the human rights code to their decisions. But the process at the Human Rights Tribunal of Ontario, or the HRTO, is that the individual first submits a Form 1, which is ultimately an application where they set out all of their complaints. The responding party has to respond by filing a Form 2. After the Form 2 is filed, the parties are invited to do mediation, which is a voluntary process. So if one party doesn't agree, the mediation doesn't proceed. And if the matter doesn't resolve at mediation, the matter proceeds to a hearing. I do note that these matters are very front loaded in terms of the work, unlike court proceedings where pleadings happen at the beginning and then the bulk of the work comes later. In HRTO matters, the parties are required to put forward all of their evidence and their entire response at the outset of the claim and then wait for a hearing date. Now, one way to expedite this process and to not wait a prolonged period of time for a hearing is to bring a summary hearing. However, that is an interesting matter that I'm going to pass over to Ryland to talk about now.
Thanks, Daz. So I want to take the remainder of the presentation to talk to you about summary hearings, which, I think are a very valuable tool in dismissing frivolous and vexatious cases before the HRTO. In fact, many human rights cases that I deal with, frankly, are without merit or at the very least should not be before the tribunal. In particular, applications that go against common corporations or property managers are prime candidates for summary hearings. Usually I find that these cases are initiated by disgruntled owners or tenants who believe they have been treated unfairly and have interpreted this unfairness as discrimination. And so when I see a case like this, I automatically think summary hearing because the reality is that the HRTO dismisses a vast majority of their cases on a summary basis. For instance, we can see in this chart here in 2023 and 2024, the HRTO issued 1,429 decisions. 97% of those, so 1,389 of those decisions in that year were dismissed on a summary basis, which is frankly an astonishing number. You can see there is a similar trend in 2022 and 2021. And honestly, I didn't look into this really until doing this presentation. And once I found this out, I always knew that there was a significant amount of cases that do get dismissed every year. I just didn't know it was this high. I guess, it's no real secret that the tribunal is overburdened and underfunded. In fact, there are stats that say that there has been a nearly 60% increase in cases before the tribunal over the last 7 years. So the tribunal has essentially developed a new way or a way trying to get an efficient way to get through these surge of cases. And in the last few years, the HRTO has been utilizing what they call the lean methodology to address inefficiencies, lack of resources, and a massive backlog of cases. And to their credit, they've said that by using this methodology, they've been able to reduce caseload of about 11% using the lean methodology. All right. Also, I just wanted to give you some perspective of how the tribunal has been handling cases involving condo corporations and property managers. So as you could just go to the next slide, please. So our firm reviewed about 89 cases that involved property managers and condo corporations from the last 5 years. And of those 89 cases, there was only one case that found discrimination, 13 cases where it was not found, and 75 cases which were dismissed on a summary basis. So needless to say, there's a high probability that any human rights application you receive will likely be dismissed by the HRTO. It's not to say they all will be, but vast majority of them will. So like I already said, we talked about it a little bit, but the way that we dismiss frivolous cases for the HRTO is the summary hearing process. During this process, the tribunal will consider whether an application should be dismissed in whole or in part on the basis that there is no reasonable prospect that an application or part of the application will succeed. Now, the HRTO can commence a summary hearing on its own initiative. However, given the caseload and backlog, this rarely happens. So it's usually upon the respondent to identify these issues and make the request, which can be done at any time after the response has been submitted. The tribunal strongly suggests that the summary hearing should be requested as soon as possible. They note that a summary hearing filed after a hearing on the merits has been scheduled will be rarely granted. So to request a summary hearing, a respondent must deliver and file a request for summary hearing form 26, which should include detailed submissions about why there is no reasonable prospect that the application or part of the application will succeed. The submissions must include all relevant facts and case law that the respondent intends to rely on to make its case. The completed request for summary hearing must be delivered, and a copy of the practice direction should be sent to the applicant and all other parties to the application before it is given to the HRTO. The applicant will then be given the opportunity to file their written submissions in response. After the submissions are received by the tribunal, it will make a decision as to whether it will proceed with summary hearing or not. The tribunal will not provide any reasons if it decides it won't proceed to a summary hearing. However, if a summary hearing is granted, it will usually be held by teleconference for about a half day. The parties will get a chance to provide oral arguments, but witness testimony or oral evidence is rarely permitted. The tribunal will then provide a written decision. If the summary hearing is granted, then the application is dismissed. If it is not granted, then the application proceeds to mediation or hearing on the merits. This whole process usually takes at least 1 year from the date that the summary hearing is requested. So again, you will want to turn your mind to this as soon as possible. So the test for summary hearing is whether an application has a reasonable prospect of success. In determining this, the tribunal will consider two things. First, the tribunal will determine whether there is a reasonable prospect of success based on the assumption that the allegations in the application are true. So the tribunal will essentially determine whether the applicant can meet the test of discrimination under a best case scenario. So in these cases, the focus will generally be on the legal analysis and whether the allegations may reasonably be considered a violation under the code. A second consideration that will be made by the tribunal is whether there is a reasonable prospect that the applicant can prove on a balance of probabilities that his or her code rights have been violated by the respondent. The applicant has to show that they can make a link between the event that led to the application and the alleged ground for discrimination. In a summary hearing, the tribunal is not tasked with determining the truthfulness of the applicant's claims or evaluating the impact of the treatment they experienced. Rather, the test for no reasonable prospect of success is applied by assuming that the applicant's accounts of the events is true, unless there is clear evidence to the contrary. So one of the most common issues on a summary hearing is jurisdiction. Rule 13.1 of the tribunal's rules of procedure state that the tribunal may, on its own initiative or the request of a respondent, dismiss part or all of the application that is outside of its jurisdiction. Now, often the tribunal will dismiss an application due to lack of jurisdiction without an oral hearing. So you don't need to go to a teleconference to have an application dismissed on this basis. Written submissions alone are sufficient. The tribunal's jurisdiction is limited to enforcement of human rights code, which only prohibits actions that discriminate people based on their enumerated grounds in the protected social areas that Stas discussed. This means that the tribunal does not have jurisdiction over general allegations of unfairness unrelated to the code. Tribunal does not have the jurisdiction to inquire into claims of discrimination and harassment in every relationship of human interaction. And the code does not assume that all adverse treatment is discriminatory. To fall within the tribunal's jurisdiction, an applicant must provide some factual basis beyond bald assertions, which links their protected grounds to the respondent's actions and explain why they think these actions are discriminatory in nature. So some case law on the lack of jurisdiction. We have Wu versus the City of Toronto and the Toronto Ombudsman. In this case, the applicant complained to the Toronto City Planner about changes to the Toronto zoning bylaws that reportedly detrimentally affected his property. He apparently did not like the response that was given by the city planner for the changes, and the applicant felt that the zoning bylaws were, and the changes that were done to his property were on the basis of discrimination. In fact, the applicant in this case was Chinese descent, and he believed that he was being discriminated on the grounds of race, ancestry, place of origin, ethnic background. The tribunal held that the applicant's suspicions of discrimination and unfairness were more likely the product of his dissatisfaction with the answers he was given to his questions about the bylaw and the effects of his property. There was no link established between the alleged offensive treatment and any grounds of discrimination prohibited by the code. And in coming to that conclusion, the adjudicator observed that although discrimination often may not be overt, the applicant had not pointed to any other information that would warrant a full hearing on the merits of his complaints. The next case we have is Senior versus York Condominium Corporation, number 212. This is a case that I actually defended over and brought the summary hearing on. In this case, the applicant was an owner and tenant of a condo unit in the condominium building. The genesis of the application was that the applicant got into a verbal altercation with the property manager about a disposal of her mattress and essentially the fairness of the condominium bylaws in this regard. The applicant alleged discrimination based on sex and ethnic origin that she said was that she felt that she experienced during her interaction with the property manager. However, she provided no objective evidence to support such allegations. And ultimately, the tribunal found that there was no jurisdiction, as what she was complaining about was largely a condo issue and not a matter before the tribunal. All right. All right. Another common issue for summary hearings involves situations of unpleasant interactions. Now, this particular issue is a prime candidate for summary hearing because the applicant usually cannot present any objective evidence of discrimination under the code. The tribunal has held that in order to prove discrimination under the code, an applicant must do more than simply rely on an unpleasant interaction and declare it must result from discrimination. The tribunal has repeatedly said that an applicant's belief, no matter how strongly held, is not evidence upon which the tribunal might find that discrimination has occurred. There must be a basis beyond mere speculation and accusations to believe that the applicant could show a breach under the code. So a case that we found on this unpleasant interaction case is Nutunga versus Ontario Number Company operating as Tim Hortons. In this case, the applicant attended Tim Hortons and ordered a soup. After receiving her order, she asked for a fork. She alleged that she was ignored by the Tim Hortons staff. Then when she asked again, the Tim Hortons employee allegedly threw the fork at her. The applicant felt humiliated by the interaction, and she felt that she was treated in this manner due to her race and ethnicity. The respondent, in response, argued that the applicant was in fact being the aggressor and was actually very rude in their interaction, and she was actually the one that threw the fork at the Tim Hortons employee. Ultimately, the tribunal found that there was no evidence that the applicant's race played a factor in her interaction with the Tim Hortons employee. And the tribunal acknowledged that while racial profiling may be established by circumstantial evidence or by inference drawn from the evidence, it still must be established. A complaint cannot, or an applicant really cannot merely point to his or her membership in a racialized group and point to an unpleasant interaction to establish a prima facie case of discrimination. So I just want to end my presentation with a few practice tips to remember if you get a HRTO application that comes before your desk. First practice tip is consider commencing summary hearing on all applications, given that around 90% of them are dismissed by the HRTO on a summary basis. The second tip is consider the context of the complaint. Is the applicant merely using the venue of the HRTO to litigate a grievance that should be before some other tribunal or board? Like we saw in the condo case that I dealt with over, the real issue had to do with the administration of the condo and the bylaws and not any actual discrimination. Thirdly, consider if the allegation is supported by the facts and objective evidence. Often in cases that are primed for summary hearing, you will see that allegations of discrimination are simply tacked on or shoehorned onto a fact scenario by bald assertions or subjective belief. All right, now we'd like to use the remainder of our time, about 2 minutes or so, to answer any questions that you may have.
So a question that comes up frequently, Ryland, is the front end loaded aspect of this. And I just want to kind of go back and just highlight this, and Ryland, feel free to chime in. What we mean by this is a lot of the investigation and the compiling of records needs to be done at the very front end of the claim. So when an HRTO complaint comes in, we immediately have to get in touch with the corporation or the property manager or the organization and gather all of the records to substantiate a response to the application. In those forms, we typically include evidence as well to substantiate our position. So, include the emails, include any interview notes, pictures, all of these things we typically have to do at the very outset of the claim. That compared with the court proceeding, where parties file their pleadings, which are a lot of the time maybe not boilerplate, but don't have to be overly specific. And then later, several months down the line, comes uh, the gathering of evidence and production of evidence. Would you agree with that, Ryland? Is that your experience as well?
Oh yeah, for sure. And the thing is that they give you about 45 days to submit your response. My experience is that they are rather okay with, as long as you get if you need an adjournment, they are okay with giving you an adjournment, as long as it's given, with proper notice. Um, but the problem with that is that the whole HRTO machine, even if you're going through the summary hearing process, takes like at least a year. So if you are getting an adjournment, then you're just delaying that process even further, and it really does move in a slow fashion. So you kind of want to get all your ducks in a row as soon as possible.
That's my experience as well. Unfortunately, we're up to our allotted time. So I thank you very much for attending our presentation, our seminar today. Please look out for our next set of presentations that's going to be coming up. And again, if you have any questions, any concerns, just feel free to reach out to myself or Rylan or anyone on our team, and we'd be more than happy to assist you. Thanks so much for your time today.
Thank you.